All right, welcome everybody. My name is Dana Sparks. I am the broker of Maximum One Greater Atlanta Realtors and the director of the Real Estate Academy of America, which is the school offering this course for CE credit. So today's course is, I know you guys are all excited. This is the 2024 Georgia Association of Realtors, or GAR, Brokerage Agreements. It is Georgia Real Estate Commission course number 77541. So today is June 12th, 2024, and the Georgia Association of Realtors, they release a new contract package January 1st of every year, and then they do a mid-year revision. Well, that mid-year revision has come out to schools, and the forms that have been revised will be available to Georgia agents as of July 1st, 2024. So you guys hopefully are all excited that today's class is going to cover those mid-year changes in addition to going over the brokerage agreements themselves. So in light of that, I am going to teach this class, not at a beginner level, which I typically don't do anyway. I see a lot of people who have taken my classes before, so welcome, and welcome back, and a lot of new people. So if this is your first time with the Real Estate Academy of America, welcome. We have a lot of classes, and I hope to see you in other classes, either with me as your instructor or with other instructors. If this is also your first time taking a class with me, I talk a lot and I talk quickly. My goal as an instructor is that my students, I like to teach in a way that you as an agent can really learn the information, and I like to teach it. My goal is to teach it in such a manner that when you are writing a contract at 9, 10 o'clock at night or on the weekend and you cannot get in touch with your broker, you haven't just memorized something or taken a class for the credit, but you really understand conceptually what you have learned in the classes that I teach. So you'll have to tell me at the end if I have achieved that goal. Additionally, I like teaching at a more experienced level, because I typically have a lot of more experienced agents on my classes. And if you are a new licensee, there is a ton of information out there that you can get, even from a colleague of yours regarding some of the basics. But sometimes it's a little bit more tricky to get some of the more nuances from the contracts. Additionally, I do have a YouTube channel called Real Estate Made Crystal Clear. My target audience in that channel are all real estate agents in Georgia, and I cover these contract issues in depth. I spend anywhere from 15 to 20 minutes or more on one particular paragraph, or one particular form. So this is a 3-hour CE class. I can't quite go that in depth, but just to set the stage for this class, I am going to highlight the changes that GAR, Georgia Association of Realtors, has made. These changes, as you would expect, are in direct response to the goings-on in our industry for the past couple of years, namely the National Association of Realtors, or NAR, settlement agreement. It has been in the court since 2019. There have been judgments, appeals, a lot going on. I'm not going into that in the class, but for the purposes of this class, the courts have preliminarily agreed to and accepted a settlement agreement by the National Association of Realtors. We are expecting final approval of that agreement and by the courts December of this year. And then after the courts approve it, the Department of Justice, or DOJ, also has to approve. The DOJ has to approve it because the basis of this lawsuit is an antitrust lawsuit. And antitrust is a federal issue that is overseen by the Department of Justice. So you will see when we get to the changes that GAR has made on the contracts for the mid-year, that they do incorporate a lot of changes mandated by the NAR settlement agreement. You will also see, again, I'm not going to point out everything as it relates to NAR and the settlement, but you will, as you study that on your own, you will notice that the Georgia Association of Realtors, thank you, Georgia. You guys, we are so very lucky in that our contract package has already incorporated a lot of the issues that have been under litigation for years in other states. So thank you, Georgia. For years, our brokerage agreements have had verbiage in there: disclosing commission, negotiating co-op fees, so forth and so on. So with that preference, we will dive in. So those changes did just come out. I'm sorry, give me 1 second. So my notes, I'm going to go back and forth. It's not going to be one fluid presentation because I have not had time to incorporate all of that stuff into one seamless presentation, but I will go back and forth. You'll see what I mean. Let's dive in. So I'm going to share my screen and we'll start. Welcome, everybody. I do appreciate your time. And my other goal is that at the end of this class, oh gosh, well, I don't know why this is doing this. All right, hang on. Hang on. This is crazy. Oh no. Okay. All right. Hang on 1 second. Do not really want computer issues right now. But my goal is at the end of this class, the time will have gone by very quickly. Okay, why is this doing this? Let me stop the share for a second. Let me try and get my computer working, and then we'll dive in. We're 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 working, and then we'll dive in. All right. Now let's see. Share my screen again. Success. All right, here we go, everybody. So again, this is 2024 Georgia Association of Realtors Brokerage Agreements and Customer Acknowledgements, GREC course 77541. I am the instructor. There is my contact information. This course is offered through the Real Estate Academy of America, courtesy of Maximum One Companies at keepmorecommission.com. 3 hours of CE credit. This is a course for 3 hours of CE of continuing education credit. No homework, no final exam. You may not take more than one virtual class simultaneously or with overlapping times, or you will not get credit for either class. The way we do attendance in this class through the school is via the chat function. I do have the chat function open so I can see it. You'll see me looking to the side. I've got another computer so I can monitor the chat as well. 3 times during this class, when you have first signed on, when you come back from break, and before you leave. If you've already done so, you don't need to do it again. But at least 3 times in those times, I am going to need your name, email address, name, license number, email address. We ask for your phone number just in case we have issues with your license number. Invariably, people transpose numbers or forget their number, and we want to make sure to be able to give you CE credit. And sometimes you give an email address. For an email, you don't check regularly because you don't want spam. I totally get that. We don't spam y'all. We just send you guys information about our upcoming classes, but that's why we ask for that information. Students may only receive credit for a specific course number once every 12 months. If you've already received credit for this course, you are more than welcome to stay, but you won't get credit. Now, you guys, what that means, it is specific course number by a specific school. You can take 33 hours of contracts classes. You will get credit for all of those different contracts classes as long as it is a different course number. Additionally, no recruiting. If so, contact me as the director of the school. The coordinator of our school is Heidi Kelly, and her phone number is below, or GREC themselves. CE credits will be recorded within 3 to 7 business days. All right. So we are going to start off with the table of contents. So a couple of things to point out to you. Wherever it is that you go to get your contracts, whether that be Remind Docs Plus or Transaction Desk or Dot Loop or wherever you go. Now, Dot Loop might be a little different because I believe a broker or you, if you have Dot Loop on your own, has to upload the contracts there. I'm not 100% sure about that. But through Remind Docs Plus, through FMLS, and Transaction Desk through Georgia MLS, you have access to all the GAR contracts if you're a realtor or if you have paid GAR for the right to use them. You guys are used to going there to pull up your purchase and sale agreements, exhibits, amendments, brokerage agreements, so forth and so on. That is also the place where you can pull up the table of contents. Not only can you see the table of contents, you can also see the GAR forms changes. And so this is a document that, again, will be available to agents as of July 1st. And you can see this states right here, these are the forms that have been modified as of January 1, 2024. And this document itself came out July 1st. So we're going to cover that. I'm going to intersperse everything as we go together. But this is all the forms available to you in the GAR contract package. And you'll see this document. You can see at the bottom of every document, if this is a document from the beginning of the year, see where it says 1/1/24. If it is one of the forms that has been revised, then it will say 7/1/24. So I just wanted to let you guys know what's there. And it is, the table of contents is organized by topic. The consumer brochures, the brokerage agreements are all forms in the hundreds. These are all the purchase and sale agreements. These are all the disclosure statements, all the documents related to financing, earnest money, contingency exhibits, amendments, miscellaneous, leasing, so forth and so on. So again, we are focusing on the brokerage agreements and customer agreements. And we are just going to dive in. I am going to intersperse My notes I have already made on the brokerage agreement with the changes, the revisions that GAR has come out with mid-year. So this is the exclusive seller brokerage agreement. The verbiage in this is the same as in the non-exclusive seller brokerage agreement, with one exception, that being exclusivity. So I'll get into that in just a moment. In Georgia, when you as an agent, and when I say agent, I also mean broker. So let me even back up further. You are all affiliated licensees. Whom are you affiliated with? You are affiliated with your broker. All contracts are written in the name of your broker. All compensation is earned in the name of your broker. How do you get paid? You get paid by virtue of having a contract with your broker, namely your independent contractor agreement. So in the contracts, sometimes they will say affiliated licensee, sometimes they will say agent, and sometimes they will say broker. In the GAR contract package itself, in the purchase and sale agreement, it does define broker, meaning broker, the person that is the qualifying broker of your company, the brokerage, and you as agent affiliated licensee. However, when it comes to compensation, you'll see a change in the mid-year revision where you can still sign, but you warrant that you have your broker's authority. So I'll get to that in a second. But in Georgia, the client relationship, when you're public buyer, public seller, public landlord, public tenant, if they want to be a client, your client or client of your broker, the client relationship is contractually driven per Georgia law. So by default, when you work with a public person and they do not sign a brokerage agreement, they are your customer. I'll get to the customer descriptions and acknowledgements later on in this class. But in order for your person to be your client, they must sign a brokerage agreement. Now, if you have worked with a person for years and years and years, they are a really, really good past client of yours, or they are an investor that you've worked with for years. You know everything about this person. You know their financial portfolio. You know what they're looking for with respect to real estate. You know what they've purchased, what they haven't purchased. You might know their bank account. If you are working with this past client in a new transaction and they do not sign a brokerage agreement, regardless of your relationship with them or your knowledge of them, they are your customer with respect to any transaction until and unless they sign a brokerage agreement. So if that is the situation, and for whatever reason that person did not want to be your client, they wanted to be a customer, you would still have to disclose that material relationship in the contract. But that's not just me saying this. This is driven by Georgia law and disclosed to our public people on the brokerage agreements. Then it goes on and it says this is exclusive. So what that means is your public person, your public seller, because this is the seller brokerage agreement, they agree to work exclusively with you to list their home or their property for sale. A non-exclusive brokerage agreement that still creates the client relationship between the public, in this case seller, if it's a buyer brokerage agreement, it'd be buyer, and you and your broker. However, they would have a client relationship with your broker, another broker, another broker. They can have multiple client relationships if they sign non-exclusive brokerage agreements. That still creates the client relationship. It's just not exclusive. Who gets paid? The broker that gets paid is the first broker that can demonstrate procuring cause of sale to get a contract and get them to closing. I will also let you know that in Georgia MLS and FMLS, I'm going to speak specifically to those. There are a multitude of MLSs in Georgia. Those are the two I am most familiar with. So for FMLS and Georgia MLS, if a seller signs a non-exclusive seller brokerage agreement, it does create the client relationship for a contract, but FMLS and Georgia MLS will not allow you to list it in their services. You may only list in those MLS services an agreement where the seller has signed an exclusive. Because think about it. If a seller signs a non-exclusive seller brokerage agreement with let's just say 3 brokers, how's FMLS going to put it on there? Which broker are they going to attribute it to? So, just so you know that distinction. But everything moving forward that's in this exclusive seller brokerage agreement is also in the non-exclusive with that exception. So you put in the property address, you put in the legal description, you would either attach a copy of the seller's warranty deed, or you're going to describe it in the warranty deed book and page. You can get that information from the warranty deed, from online records, gsccca.org, or your closing attorney. These are the order that they are most accurate. The actual warranty deed itself, and then the warranty deed book and page. A lot of agents fill out number 3, but if you don't have all the information, it's not really a complete legal description. However, it is definitely helpful to fill out the subdivision information. Then you're going to put in the price, and you're going to put in the beginning date of the agreement and the end date of the agreement. So this is the beginning date of the client relationship between the public seller and your broker. This is the end date of that client relationship. It cannot be open-ended per Georgia license law. Then we have a section on marketing. This is where you agree to put the listing in the following MLS services. And you're going to write out the MLS services where you're going to market this listing. Now, because, well, it goes on to say, delivery of agreement to and listing with an MLS listing service. This agreement must be timely delivered to and listed with the above referenced MLS services in accordance with the rules of such multiple listing services. This obligation shall control over any conflicting or inconsistent language therein. And then it goes on to say marketing commencement date. This is the date when the property is first marketed to the public. Seller shall have the right upon notice to the broker to move this date up or back by not more than so many days. So let's talk about this just for a minute. Paragraph 2 is the date the client relationship begins. FMLS and Georgia MLS, by their rules, if you state that you're going to list it in one of those or either or both of those listing services, you have to list it in their services within, I apologize, I think it's 48 business hours. And what this section says is the membership agreement with the MLS services supersedes any special stipulation you have here. So here's the issue. The issue is, what if you go on a listing appointment and the seller wants to hire you as their agent and they want to get the house up for sale, but let's say they have some repairs they have to do, or let's say they want to repaint a room. They have their kids' room in the house was painted hot pink, and they want to paint it back to a neutral color. So it's going to take a while to do that. Or they're going on summer vacation and they're not going to be back for 2 weeks. So you don't want to not sign, you don't want to post date the agreement because it doesn't start, you want it to start when you're there and get them as your client. You don't want another broker coming in and taking them as your client, as the client in that 2-week interim. But MLS says now that you have it listed, now that you have it, the agreement signed, you have to list it, but they're not ready. So what do? That's why we have this separate section on marketing, the marketing commencement date. So let's say today is June 12th. So let's say you're on a listing appointment today and you want to sign, they're ready to hire you today. And, but they're going on a vacation. I'm looking at a calendar. They're going on vacation and they won't be back. They don't want people coming in their house until Monday, June 24th. So what do? So what you do is you fill in the commencement date today, June 12th, 2024, whatever end date you have, the marketing commencement date, and let's say you're putting it in FMLS, the marketing and Georgia MLS. The marketing commencement date is going to be June 24th. Okay? So you signed today, begin the client relationship today, but they don't want you marketing it to the public for a couple weeks. What do you do with MLS? Well, this says you have to list it in the listing service. And again, I believe it's 48 hours. I should have looked that up before and I apologize. What do? Because you don't want people coming in. That's for that. What you do is you change that dictates the status or the label of the listing in MLS. So you still have 48 hours to put it in FMLS and Georgia MLS, but the status is not active. It's coming soon. So that is the appropriate use of a coming soon listing. Because you're not marketing it to the public yet, it still has to go in the MLS service. A coming soon listing may not be shown to anybody. Nobody can see it. Another agent can't see it. You can't show it to your own potential clients or customers or prospects, but it does have to go in the MLS service. So that is the difference between the marketing commencement date and the beginning date of the client relationship. Now, this section on commission, I'm going to switch to the mid-year changes. This whole paragraph got changed. So, switching gears. These are the mid-year changes that GAR made. For the purposes of this class, I'm going to cover the changes to the brokerage agreements and customer agreements because that's what this class is. There are for you commercial agents, there are a lot of changes to commercial, changes to instructions to closing attorney. I will cover these. I'm going to cover everything that has to do with commission. But here we are on let me just show you where we are. We're still on the exclusive seller brokerage agreement, but we are on the new revised version. One thing they did, instead of saying broker, they just defined it. It now says seller's broker. So now let's talk about commission. First thing you will notice throughout the entire GAR contract package, and you will start to notice in everything that you're seeing online, Facebook, whatever, the switch is being made from talking about agents and brokers earning commission to changing the word to compensation. So everywhere the word commission has been used in the Georgia Association of Realtors contract package, it has been changed to compensation. This is a brand new paragraph, and it states, compensation to brokers is negotiable and is not set by state law. That verbiage is directly in response to the NAR settlement agreement. That has to be in the brokerage agreements and in the customer agreements. Then it goes on to say, however, this does not obligate individual licensees and brokerage firms to necessarily negotiate their compensation. A business, a brokerage, and you as an agent, as an independent contractor, now your decision as an independent contractor, that depends on your broker's policies. For example, at Maximum One, we treat our agents as the CEOs of their company that they are, and we do give them the leverage to negotiate their compensation as they see fit for running their own business, as long as what they do is legal, ethical, compliant, and professional. Other brokers have certain policies regarding compensation that their agents are allowed to charge buyers and sellers for their professional services, and they can't vary from that. So by state law, they are negotiable, not set by state law, but it's not an obligation on behalf of a brokerage, because the public has the option of interviewing different brokers. Okay, goes on to say compensation to seller's broker. Seller agrees to pay seller's broker the following compensation at the closing of any contract to sell. And so what the seller agrees to pay you, their broker that they have hired to sell their property, that amount can be expressed either as a percent of the sale price, a flat fee dollar amount, or some other arrangement. Then it goes on to say, optional compensation for buyer's broker. The seller hereby approves of the following compensation, if any, being paid to a buyer's broker, either by the seller, in addition to the compensation being paid to the seller's broker, or compensation to the buyer's broker being paid by the seller's broker out of the compensation being paid to the seller's broker, or sell a combination between the seller and the seller's broker. That amount is expressed as a percent of the sale price, a flat fee, or other. So don't get confused by this. It sounds confusing, but don't get confused. You guys are all used to this. Let me show you what it used to look like. It used to be, this is the amount the seller agrees to pay you for listing and putting their house up there and getting their house sold. This is what they agreed that you could share of this total commission, the amount that you could share with a buyer's broker to cooperate. This is the co-op fee that we're used to talking about. And again, in Georgia, we've always had it, not always, but for several years, that the seller allowed that, or did not allow that. The change being made moving forward is a little bit different. So this is the total amount a seller is paying you at closing. Then this is an amount that they agree can be paid to a buyer's broker, an agent / buyer that brings a motivated, qualified buyer, goes under contract, and that broker is also going to get paid. So if the seller can say, look, I'm going to pay you a big total amount of percent of the sale price of the amount I am paying. Okay, let me start with the first option. I'm going to pay you, my broker, a certain percent of the sale price at closing for doing the job I hired you to do, for the professional services you give me. In addition, I'm also going to pay a broker bringing a buyer at closing. So this would be, again, this is the amount they're paying you. This is the amount the seller is paying in addition to paying you at closing the buyer's broker. Or the seller can say, this is the amount I'm paying you. Out of this total amount up here I'm paying you, you are to share a portion of that with an agent or broker bringing a buyer. This down here is the amount of that you're sharing. That would be the second box. That is what we typically in the past have referred to as the co-op fee. That is the co-op commission, now compensation, that of the total compensation the seller is paying you, you are sharing with a buyer's agent, a buyer's broker. If that is the situation, then this amount is larger than this amount because of the total amount the seller's paying you, you're sharing part of what you get from the seller with a buyer's broker. That's the second box. That's the one, I'm not even going to use words. That's one that may be more familiar with a lot of agents. Then this third option is it could be a combination. The seller can say up here, okay, listing agent, I'm going to pay you this amount. I understand, and I want to give incentive to another agent or broker that's working with buyers to come to my house and have them see my house and write an offer and buy my house rather than another house. So I'm going to compensate that buyer's broker. I'm going to give them a little bit extra out of my pocket, and I want you to share part of what I'm giving you. That would be this third section, that the compensation to the buyer's broker is coming from both the seller and the seller's broker. And if that's the situation, you do need to describe other. How is that being divvied up and under what circumstances? The next section is if the seller's offer of compensation to the buyer's broker is conditional, and this is if the seller's offer of compensation to the buyer's broker is either coming from the portion that you are instructed to share with them or from the seller themselves, then you specify the conditions here. This has been in the GAR contracts for several years. It's really interesting because this is now part of the NAR settlement agreement. When you hear that there's no quote unquote unilateral offers of compensation, this provision, again, Georgia has had Georgia agents, they have had our backs, and the Georgia Association of Realtors has protected us and had this in our contracts at least 3 years, probably more. I lost sense of time since the early 20s because of everything going on in the world. But so this could be a variety of circumstances. If the seller's offer of compensation to broker is conditional, specify the conditions here. That could be based on a dollar amount. That could be something like, if I get a contract within by such and such date, then the buyer's broker compensation is X versus Y. Or this could be where the seller agrees to a bonus. It could state if we go under contract by such and such date, then buyer's broker, I will compensate buyer's broker with a bonus of X amount of dollars. Or it could be something to the effect of, if seller's agent shows buyer property without buyer's agent being present at first time of showing, compensation shall be X versus Y. So if anything is changing or conditioned upon, if the amount the buyer's broker is being paid is conditioned on something like I just gave as an example, the seller must agree, and that is specified here in this section. So again, conceptually, it's not a lot different from what we're used to in Georgia. There are some more specifics regarding compensation to a buyer's broker and where is that buyer's broker being compensated from the seller's side. We'll come back to these changes when we get to the corresponding paragraph. So I don't see anything in the comments. So hopefully that was a pretty thorough explanation. All right. It does go on to say separate commission on a lease. You guys don't leave this blank. there are situations where you could list with a seller and they want to sell their house, but they could get an offer and it's a lease purchase, or something could change and they never thought about leasing their house, but they get an offer from someone to actually lease their house rather than buy it outright, and they decide that's what they're going to do. So there are a lot of circumstances where initially a seller doesn't think they're ever going to go into a lease, but they end up going into a lease. Well, you need to get paid commission, and again, it does say compensation now, and it states if the seller leases the property or enters into a lease purchase agreement or a lease option, the seller shall also pay broker a separate leasing commission in the amount of blank amount of dollars, and as follows. This as follows is typically, I got to stop using the word typically, could be something such as the seller agrees to pay their broker, if you go into a lease or a lease purchase, X amount of dollars, and this could be at the time tenant takes possession, or within 3 business days of the sign, a fully executed lease or something like that. But you put how much and when it's due. Then it goes on to say, notwithstanding any provision to the contrary, the payment of a leasing commission shall not relieve the seller from paying the commission at closing of a contract to sell. So you've signed a listing agreement to sell the house. If for whatever reason the seller leases it, and at some point, especially if it's a lease purchase and they go back to sell it, they're still obligated to pay you the commission on the sale. This is separate commission on a lease. Then you fill in the protected period of so many days, and we'll cover that in just a minute. Agency and brokerage. Point of practice to you as agent. Some brokers have this as a policy, but you guys are all independent contractors. And I highly suggest that, especially in light of everything going on, and it's always good business practice, you need to get as much information into the hands of your public buyers and sellers as possible. And GAR has many, many documents, brochures, disclosures to help you. Your broker might have a lot of information, and you can learn information from a class. I will tell you that prior to using any document or disclosure you get from somewhere other than your broker, meaning from a closing attorney, from a class, please make sure to get your broker's permission prior to using that in your practice. So when we're talking about agency, you have to disclose what types of agency are not being offered by your broker. Seller agency, buyer agency, designated dual, sub-agency, so forth and so on. It goes on to say that if the broker offers dual agency, the seller does or does not consent. Again, you guys do not leave this blank, especially related to dual agency. Dual agency is legal as long as it is disclosed and you have written consent from both buyer and seller. There are several places throughout the GAR contracts where the public gives their consent. The brokerage agreements and the purchase and sale agreement. You have to be able to demonstrate that you've provided your public with information. The difference between an agency or client relationship with your broker and a customer relationship with your broker. And again, a lot of that has to tie in specifically with dual agency. And it says dual agency as that agency is explained in section B6 below. And in the ABCs of agency, seller expressly consents to broker acting. ABCs of agency. Though that is a wonderful GAR document, again, available to you. Here it is. Hang on. Available to you in the GAR contract package. Again, point of practice, you listing agent, well, every agent, y'all should have this with your buyers and your sellers. to explain to them what agency means, what real estate brokerage means, what it means to be a client. And this document, this consumer brochure, does go through that. If a public person chooses to not be your client, then by default, they are your customer, and you may perform ministerial acts. I have a handout that I will be more than happy to share with you. Again, caveat, please run this by your broker prior to using this in your practice. Your broker might have their own document describing ministerial acts, but this is ministerial acts in Georgia. This is directly verbatim from the Georgia Real Estate Commission newsletter back in 2021. And it is in reflection, a restatement of Georgia license law, which does define ministerial acts. It also references Beretta, or brokerage relationships law in Georgia, gives examples of ministerial acts, and it goes on for GREC license law, Rule 520-1-02 definitions of what it means to be a customer, a client, what it means, how discretion and judgment are defined, and again, more information about ministerial acts. If you work with the public as a customer, these are the only things you can do. If you work with the public as a client, then you can use your discretion and judgment. And these two documents, I, again, point of practice, encourage every agent in Georgia to have these and give them to all of the public with whom they work. All right. Moving on, lead-based paint. We know from the EPA that if a property was built prior to 78, there is the chance that the paint used had lead in it, and you must disclose that to any potential buyer. Additionally, you listing agents, you guys are in the house. When you're doing your tour of the house, if you see anything in the home that looks antique or reclaimed barnwood, antique mantelpiece, anything that could be painted, varnished, anything prior to 1978, I encourage you to also use the lead-based paint brochure. It's at this point in the class, I always get asked, well, should I just use the lead-based paint disclosure exhibit and brochure on every listing? That is a question to ask your broker. It is required by the EPA, by federal regulation, to use it for houses built prior to 78 or anything therein. And this information must be a buyer, you buyer's agents, you need to have this information too, because a buyer has to have this prior to writing an offer. So listing agents, y'all need to fill out this disclosure and have it available in your listing services or as a handout in that property to any buyers, because they have to have it prior to making an offer. The listing agreement says that when your public seller signs this listing agreement, they also agree to sign, here's what it says, it's the lead-based paint disclosure F316. They agree to complete this and sign it at the time they're signing this listing agreement. You buyer's agents, if you don't have it from GAR, or there's also, you can get the exact same disclosure from www.epa.gov. And there is a lead-based paint consumer brochure that is also available at epa.gov. GAR just got them directly from the government website. So anyway, you mark that. Then this next section on special circumstances. It talks about bankruptcy, divorce, or a short sale or other. You guys, this is you only complete this part if your seller is in the middle of a bankruptcy, is in the middle of a divorce, or so forth and so on. And the bankruptcy court must sign to approve of the seller listing the house, or must sign to approve a contract. The divorce court. Y'all, if you're dealing with people that are in the middle of a divorce, you absolutely need to check with their attorney and make sure where they are in that divorce. And typically, a divorcing couple cannot list a house for sale without the court's approval. So if the divorce has been finalized and you have a divorce decree, and the divorce decree states they have to sell the house and divvy up the proceeds, that is, you do not fill out this section. This is just, it says right here, require third-party approval before doing the following. And then this section says the seller does or does not authorize you to assist them in negotiating their contract. Okay, then we move on to all the fill in the blanks are in the first part, except for the special stips and exhibits, then we go on to the legalese, or the further explanation of what the seller just agreed to in the negotiation part that we just filled out in the paragraph A. And again, this first part is exclusive, so the seller acknowledges that they are not a party to any other exclusive seller brokerage agreement, and if so, they may have to pay their previous broker a commission if it was terminated without the consent of the previous broker. And then this section about list price, I love that GAR put this in. If the property fails to be shown or sold at the list price negotiated in this agreement, it could be an indication that the list price of the property is too high. That would then prompt a further discussion with you on adjusting the price as the listing period goes on. Now, what happens? Remember, we filled in here, by license law, you have to have an end date, right? We have to have an end date to this agreement. So let's say we're listing it today. Let's just say the end date of our listing agreement is June, July, August, September. Let's just make it the end of the year. Let's say our listing agreement ends December. It's going to be easier for me to talk through. December 31st, 2024. Okay? That's what we filled out in A2C. So now what happens if, I'm going to go back to here. Sorry if I'm making you dizzy. What happens if you get a contract, hopefully in this market, it's not going to take you that long, but let's say you get a contract on December 15th, and it's not scheduled to close until January. We're going to close January 15th, 2025. But my listing agreement expired December 31st, 2024. What this paragraph says is, if the property is under contract at the time this agreement expires, but we haven't closed on the contract, then the listing period shall automatically be extended through closing. So right now, my listing agreement expires December 31st. I'm under contract, not scheduled to close till January 15th. This agreement automatically gets extended through January 15th. That's what that means. Now, what happens if this next section about extension, let's say we have it listed, we go under contract with a buyer. Let's say we're under contract for 5 days, and on the next day, the buyer sends us a termination. They terminate under due diligence. Well, you as the listing agent, you were off, the seller's house was off the market for 5 days. You were under contract for 5 days, but that contract terminated. What happens to your listing agreement? This paragraph states that if you were under contract, but it was not consummated, it didn't close for any reason, the listing period may be extended unilaterally by the broker for the number of days it was under contract. But so it's an automatic unilateral extension, but you have to let the seller know. And you have to let the seller know in writing within 5 days. And if you don't do that, then you lose that extension. So what does all of that mean? And if you don't do that, then it's not extended. Okay, blah, blah, blah. What does all that mean, Dana? Okay, back to my example. We're under contract for 5 days. Buyer terminates. I'm back on the market. Instead of my listing agreement terminating 12/31/24, I can automatically add those 5 days on. So now our listing agreement expires 1/5/25. However, I have to notify the seller that I'm going to take advantage of those 5 days in writing, and I have to send that to them within the 5 days that buyer terminated under due diligence. How do you notify them? GAR has a form, F5158, Notice to Extend Brokerage Agreement. And this is this is the lead-based paint disclosure, just as an example. And again, it must be filled out. Just wanted to show you that per our previous discussion. And this is the lead-based paint disclosure, F316. Okay. This is the extension notice. This is F158, Notice to Extend Brokerage Agreement. This also applies to the buyer's brokerage agreement if we're extending that under the same circumstance. You give the date that you're sending the seller notice regarding your seller brokerage agreement, which was dated between you, the client's name, and the broker's name. In accordance with this agreement, gives notice that this is extended, in my example, through 1/5/25. It is unilateral, so you are the only one that needs to sign it. So again, F158 is the document you use to notify your seller that you are extending the listing agreement. And the only way you can do it unilaterally is if the seller was under contract and that contract terminated. Moving on to the marketing section. There's a couple of things here. Any media, the seller gives you permission to market their property in any media you choose, online, through flyers, through pictures, through direct mail, whatever you choose, they give, through an MLS service, they give permission. It goes on to say that in listing the property in an MLS service, all MLS and real estate brokerages related third parties have access to the listing information, including pictures, videos, and the right to use all of that as related to the listing. It goes on to disclose to the seller, look, we're in a huge technology world. I don't have control over how the MLS services syndicate these listings to public sites like Zillow, Trulia, Realtor.com, Homes.com, other brokers, so forth and so on. So just know I will do my best to make sure if something is incorrect to inform those that it is incorrect, but I don't have control over that. It also goes on to say that any media, this is any pictures, photographs, recordings, videos that you create or you buy for your marketing efforts, they do not belong to the seller. They belong to you. And the seller warrants that any media that they give you or they pay for belong to them. This is not important at this stage in the game. However, if for whatever reason, later on, let's say they have a gorgeous kitchen and you've taken pictures of their kitchen or you've paid for pictures of their kitchen, and it is so beautiful that you want to use a picture of their kitchen for your general marketing, not selling another house for sale, but just your general marketing. You want that as a beautiful background shot on your website or so forth and so on. Because you have taken the picture or paid for the picture, that belongs to you, and you have the right to use it in any of your marketing, even not marketing their home. However, listing agents, if you guys charge your sellers, some listing agents will have their sellers pay for professional photographs. If the seller pays for it, you need their written permission to use it anything outside of marketing this house for sale. Likewise, if you've taken pictures or paid for pictures and you give them to the seller, and for whatever reason you don't sell the house, your listing expires, they list with another broker, and they give the pictures that you took or paid for to another broker, they can't do that without your written permission because they belong to you. So that's what all of that has to do. It goes on to say, in compliance with license law, that the seller gives permission to put a for sale sign on the property with their signature here. And they can also mark it as under contract when it goes pending and being sold when it closes. This goes on to say, nothing shall permit the broker to place a sold sign on a property no longer owned by the seller. So you guys, just because we're here, this is a great lead generation tool for you buyer's agents. So once you close, the seller no longer owns the house and the seller's broker no longer has a client relationship with the owner of the house. So once it's sold, you listing agents, you cannot put a sold sign on there. However, who owns the house? Y'all, I need some interaction. So type in the chat, at closing, who owns the house? Type in the chat. Who owns the house at closing? Yeah, the buyer owns the house. So license law says you have to get written permission of the owner to market or advertise the house, including putting a sign in the yard. So you buyer's agents, at the closing table, get some document signed by the buyer that you can now put up your sign in their yard with a sold name writer. That is a great lead generation tool because everybody driving by is going to have seen the listing agent sign. Sorry, listing agents. Everybody's going to have seen the listing agent sign, and now they're going to see the sold sign, the sold name writer with your sign. And the listing agent has to take their sign down. So, who might get additional listings from that? Buyer's agents. Now, if you buyer's agents don't want sellers, you can give, or you listing agents, you could get the buyer's written permission. But just know in general that that is a lead generation tool. It is provided for in the contract. What's going on? It is provided for in the contract, and it's in compliance with license law. All right. It also goes on to say, because of pictures and videos and people going in the house, sellers, go remove all your valuables so that they're not photographed in the house, and we have no control over that. Then again, it goes on. We've already talked about this with respect to paragraph A. If you're listing it in an MLS service, oh, here it is. I was wrong. It's within 1 business day. Okay, I'll back up. This says, if you agree to list it in an MLS service, you have to put it in as active within 1 business day of the marketing commencement date. That's when it's made available to the public. And then it goes on to describe, what does that mean? Marketing of this property to the public includes flyers, yard signs, digital marketing, public-facing websites, brokerage displays, so forth and so on. Internal marketing that only goes to other licensees within your firm is not public marketing. If you're talking about your listing at a sales meeting or have a flyer in your office, that is not public-facing marketing. And then this is regarding you talking to them with respect to the do not call list. And this says lockboxes against seller. We don't have control over everybody that's in your house. We do have lockboxes. Point of practice to an agent. You guys really should do everything that you can to include an electronic lockbox that does track who has access to it rather than a combination lockbox. But seller, you agree to remove valuables, prescription drugs, keys, so forth and so on. Goes on to say, no marketing by the seller. Seller, you cannot market the house on your own without my written permission. Why? Well, because you have signed an exclusive listing agreement with me. I'm entitled to compensation for the professional services I render. I do not want there to be any issue about you bringing a buyer versus me bringing the buyer and having any discussions on compensation. So the agreement itself cuts that off before you ever have to go down that path that says you're more than welcome to market it, but you have to have my written permission first. And then under this commission section, let's switch back to the revision. So under the revision, again, all of this is the same. I just have my notes highlighted in the older versions, in the January version. So in the July 1st version coming out, this is the GAR revision under the corresponding paragraph to compensation. New title to this paragraph, compensation for professional services of the seller's broker. Obligation to pay compensation to the seller's broker. In the event the seller enters into a contract to sell, lease purchase, blah, 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 during the term of this agreement with any buyer, seller agrees to pay the seller's broker's compensation at closing, regardless if the closing is before the expiration of this agreement or after, and if applicable, the leasing commission. It goes on to say optional compensation to the buyer's broker. That's what we've talked about before. Seller shall have no obligation to pay the compensation of a buyer's broker. That's just a flat out statement. However, again, that's to be in compliance with regulations and agreements. However, some sellers approve such compensation being offered and paid for by either the seller or the seller's broker. If the seller has agreed to pay compensation to the buyer's broker on any contract to sell, it shall be paid in full at closing. If the seller does not approve of paying compensation to the broker, then the buyer shall be solely responsible for paying the buyer's broker's compensation. This where it says seller shall have no obligation to pay compensation of buyer's broker. That's only if they did zeros here or did not authorize any compensation to a buyer's broker. But if the seller did authorize compensation to a buyer's broker in paragraph A4, then they have to pay it. Paragraph B4 is just describing that they have to pay it at closing. And then it goes on to say that they also have to pay compensation on a lease, so forth and so on. So again, obviously the corresponding paragraph changes based on what they had filled, based on the corresponding paragraph in the new revision as of July 1st. All right. Protected period. This gets a little bit confusing. So I'm going to go through this. I'm going to finish the listing agreement. We're going to talk about the authorization to show unlisted property, and then we'll take a break, dive into the buyer agreements, and then we'll cover at the end, we'll cover there's a new compensation form and changes to the instructions to closing attorney. So hang in there with me, and we will take a break. So protected period. So remember in paragraph A5, there is a fill in the blank for a time frame. Y'all don't leave that blank, fill in a time frame. What does the protected period mean? It says the protected period is the period set forth in the agreement commencing upon the expiration or the unilateral termination of the agreement by the seller, during which the broker shall be protected for its commission as applicable. So just let me, before I go on, because there's a lot in this paragraph. Again, keeping with our example, let's say the listing agreement expires 12/31/24. And let's say you had a 60-day protection period. That would mean that until the end of February, just generally, we're gonna ignore that February and only has 28 days, but till the end of February, if you had a 60-day protection period, it would be actually March, whatever. But anyway, you know what I mean. Your commission is protected. That's the time frame. But hang on, there's lots of strings attached. It also goes on to say, now let's say our listing agreement expires December 31st, 2024, but let's say let's say that our seller unilaterally terminates this agreement. They fire us for whatever reason on September 30th, 2024. So the listing agreement goes till the end of December. They fire us the end of September. So October, November, December. They fired us 3 months short from the actual expiration of this agreement. What this paragraph states is our protection period of 60 days is still for 60 days from the date they fired us or unilaterally terminated. So in my example, September 30th, we've got 60 days plus the time frame that was left on the original agreement. So our protection period still goes, if we had a 60-day protection period, still goes through the end of February, because we still get protection for the time frame that was left on our agreement before they unilaterally terminated, plus that time frame. That's what all this says. So how is your commission protected? Well, it's protected if during that time frame the seller enters into a contract which during the term of this listing agreement, the buyer saw the property, identified the property, or it was shown either in person or virtually, was provided specific information about or inquired about either directly or through a broker working with a buyer, then the seller shall pay the broker at closing of the commencement, blah, blah, blah. Okay, what does that mean? That means your commission is protected if during the time frame of this agreement, so from, let's say we signed it today, from June 12th, in my example, through the end of February, if a buyer that saw it during the time, okay, let me back up. If a buyer sees it during the time the listing agreement is active, either through your efforts and they either see it, it's identified, or they submitted to, or through a broker working with a buyer, you marketed the listing to other agents and another agent was working with a buyer. If that buyer comes back and buys the property after the expiration of this agreement during your protection period, you are entitled to commission. So what does that mean? That is a hint. Listing agents, y'all need to keep track of the buyers. What that does not mean is it's not a blanket protection for any buyer. So it does go out throughout the internet, so forth and so on. You have to be able to identify the buyer. And it's not just a shotgun. I'm working with buyers. I have them set up on an auto drip from MLS. You have to be able to identify that you had some meaningful conversation with a buyer, or you had some interaction with an agent working with a buyer that showed the property while you had it listed. So what does this mean? This means listing agents, at the end of your listing agreement, or actually as you're going through, y'all need to keep a list of any actual potential buyers that see the house, or you might not know the name of a buyer working with a certain agent, but you need to keep track of those. Super lockbox reports are handy dandy. You need to keep track of the buyer's agents that showed the property while your listing agreement was active. You need to be able to provide this list to your seller at the end of your listing agreement if you did not get it sold. Okay, that's how your commission is protected. However, all of that gets thrown out the window and your commission is not protected if, and that's what this next paragraph says, notwithstanding the above, meaning we throw out everything I just covered, if the agreement expires, an exception to the above shall apply, and no commission is due if the seller goes under contract and closes with a buyer. It's worded a little weird here, but it says buyer through another licensed broker with whom the seller has signed an exclusive seller brokerage engagement agreement. So what does that mean? That means your protection period goes away even if you can identify the buyer or the agent that was working with the buyer. As soon as this seller signs another, your listing agreement expires, your seller signs another exclusive seller brokerage agreement with another broker. Then a buyer comes back and buys that house. Your commission is not protected. So let's say you have the house for sale. Let's say we're the end of December. We know our listing agreement expires 12/31/24. We get an agent that shows it on 12/30, and we contact them. Did they like it? Did they like it? Are they going to write an offer? Going to write an offer? Well, I don't know. It's between your house and another house. 12/31, New Year's Eve comes. Are they going to like? Are they going to write an offer? Are they going to write an offer? Well, I don't know. They're deciding between your house and another house, but your house is looking good. Your listing agreement expires at 11:59 p.m. on 12/31/24. January 1st, everybody is celebrating the new year. January 2nd, your sellers signed a listing agreement, an exclusive seller brokerage agreement with another broker. January 3rd, you get an offer from the agent that showed your house on December 30th. Are you entitled to that commission? Is your commission protected? Put in the chat, yes or no. Agent showed it before your listing agreement expired. Seller signed 2 days later with another broker to sell their house. They signed a seller brokerage agreement. The next day, you get an offer from that agent that showed it while you have it listed. Per this paragraph, are you entitled to commission? The answer is no. That's what this paragraph means. This paragraph says the moment the seller signs an exclusive listing agreement with another broker, there is no more protection for your commission. No more protection, even if you can identify the buyer. Your commission is only protected if they do not sign another seller brokerage agreement with another seller. That's why I have a star by this paragraph. You guys, it's not protected if it just expires automatically. Now, this last sentence, however, says this exception shall not apply if this agreement is unilaterally terminated by the seller. So if this agreement just expires at the end of 12/31/24 and they sign with another listing agent, even though you can demonstrate a buyer's agent showed it while you had it listed, no commission due to you. However, let's say the seller unilaterally terminates this listing agreement in August or whatever, and the same scenario, you would be entitled to a commission because a unilateral termination of this agreement is a default by the seller and your commission is protected. So you again, this just so you understand that it's a little bit confusing and complicated the way it's worded, but I hope I've described it with my example. Woo! Okay, there was a question prior to this. Hang on, the question was... Give me 1 second. I just saw it. Okay. What about sold postcards for the listing agent? Yes, a listing agent can do a sold postcard. It's just marketing that. You just can't put a sign in the yard. It's marketing that specific property for sale that is addressed in license law. You can do just sold postcards. Good question. Okay, moving on to agency and brokerage. Again, we've talked about dual agency. Dual agency specifically is legal by Georgia license law. You need to check with your broker on your broker's policy. It is legal with disclosure and written consent. There is written consent throughout the brokerage agreements and the purchase and sale agreements. Hang on, I've got one more question. Is there any info on if seller's offer of compensation is only in the event no compensation offered to the buyer's agent from the buyer? So as a listing agent, you are not going to know that. And at the end, I'm going to cover a couple of the new compensation agreements. So keep that question in mind. We're going to address that at the end with the new revisions, a couple of new forms that came out. So good question. I'll get back to that towards the end. All right. So again, this is just disclosures regarding dual agency. What it means that they have to agree. If they consent, that's what they're agreeing to. Again, I highly suggest you use the ABCs of agency and ministerial acts. Designated agency, that would be one broker and two agents. One agent has a client relationship with the seller. One agent has a client relationship with the buyer. Easiest way to think about that is the broker. Remember, all contracts are in the name of the broker. So the easiest way, and where the term came from, is the broker designates agent A to represent the seller, and I designate agent B to represent the buyer. And then you have to disclose that. Lead-based paint, we've talked about that. Special circumstances, again, we said it is, you fill that out if it is contingent upon third parties' approval. All right, let's talk just a little bit about the seller's property disclosure statement. So Georgia law states, and they reference the law there, it's the law on the laws on fraud. It states that a seller must disclose known latent defects in the property which could not be observed by a buyer upon a reasonable inspection. This is the case even if the property is being sold as is. Now, you listing agents, if you, license law and Realtor Code of Ethics states that if you have knowledge of a latent defect by virtue of your license and your status as a realtor, you must disclose that. Even if the seller says don't tell anybody, you have to disclose that. But for a seller disclosing latent material defects that could not be observed by a buyer upon a reasonable inspection, there is nothing in law that says the seller has to fill out any specific form. They are not required legally to fill out any of the GAR property disclosure forms. However, the listing agreement, the seller brokerage agreement, says that when they sign this listing agreement within 3 days, they do agree to completely fill out a seller's property disclosure statement. There is a full-blown seller's property disclosure statement, or there is a shorter 2-page version, just disclosure of latent defects and fixtures checklist. And shoot, I don't have those. I can show you quick. Well, you guys know what those are. If you don't, let me know and I'll show those a little bit later. So you listing agents, if you have a seller that says, I have no knowledge of any latent material defects, and I am not filling out that full-blown 8 or 9-page disclosure statement because I don't know about leaks or when it was fixed or blah, 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 and I don't want to warrant any of that information, and I don't want any of that in writing for whatever reason. I don't want to fill out the short one. If you have a seller that does not want to fill that out, they are not required to by law if they have no known knowledge of latent defects. But the listing agreement requires that they do. So what do? you are going to add a special stipulation to this seller brokerage agreement that says, per paragraph C1, seller opts to not complete any seller's property disclosure statement, and seller has no known knowledge of any latent defects. So you would add a special stipulation if they don't want to fill that out. If they don't want to fill that out and you don't add a special stipulation, they're really they're going against what they've agreed to do by signing this agreement. It goes on to say hazardous conditions on the property. Okay, seller, you have a duty to keep your property safe. It's in all caps. You know it's important if it's in all caps. So if you have broken stairs or a broken floorboard or broken window or something that is not safe for any prospective buyer or their agents or anybody coming into the property, you have a duty to put up a sign and warn people of such dangerous conditions, especially that would not be obvious. If somebody gets hurt, you agree to indemnify and hold the broker harmless from any and all lawsuits. Goes on to talk about limits of broker's authority and responsibility. It says, okay, seller, you're giving me permission that I can show I have a client relationship with you by virtue of signing this, but I might also have a buyer that would be perfect to buy your house. I have your permission to show prospective buyers. Additionally, I have no duty. I'm a real estate agent. I'm not an inspector. I have no duty to inspect the property or to advise you on anything related to the property. I'm not a tax person. I'm not a termite person. I'm not an attorney. I'm not a construction expert. I'm not a roofing person. I'm not a mortgage consultant, so forth and so on. I'm not a zoning expert. It defines and gives examples of some of those experts. Sellers should seek independent expert advice regarding any matter of concern to you as the seller. I owe no duties to you, the seller, other than what is set forth in this agreement. And I'm not, if you lose out on a contract or earnest money or something like that because you miss a deadline, I'm not responsible for that. You are responsible for complying with duties and deadlines. The seller agrees to indemnify you and hold you harmless for any incomplete or inaccurate information or earnest money handled by anyone other than my broker. You agree to indemnify me from any loss or theft of valuables. And if you have material facts about the property you know and you don't disclose them to me, you can't hold me harmless from them, again, with dangerous or defective conditions. Goes on to say, I cannot bind you to terms. Any agent-to-agent communication I do, even in writing, does not bind the party to any of the terms that we talk about. So you agents, when you guys are going back and forth in your emails, or even if you prepare an amendment or an exhibit and it is not signed by your buyers and your sellers, it is not binding upon your buyers and your sellers. Goes on to talk about limit of your liability. If there was a commission being paid and that term is going to be changed to compensation, then your liability is limited by that amount that you were paid. If there was no commission or compensation earned, your liability is limited at $100 as a result of loss of money by wire or cyber fraud. This goes on to say that based on Georgia residential mortgage fraud, the seller gives you permission to report any suspicious or unusual or illegal fraud. And we're not fraud experts, but it's just a disclosure of that. Miscellaneous arbitration. This goes on to say that if there are any issues, we agree to go to arbitration first, and any claims, all claims shall be brought by a party on his or her individual capacity, not as a member of a class action. This has been in our Georgia contracts, I believe, since 2015. So you agents, you on this class that are paying attention, all the issues in the news are having to do with a class action lawsuit. This says that any sellers, and again, I believe it's been since around 2015 or 2016 that GAR has had this. Thank you so much, Georgia. We are so lucky to be agents in the state of Georgia with the Georgia Association of Realtors protecting us. This says that you agree to not be a member of a class action lawsuit. Just saying. This section about assignability, this does not mean if you're working with a buyer, an investor who wants to assign a contract. This is if the listing broker sells their business to another broker, then all listing agreements, all contracts get assigned to another brokerage firm, and you agree to that. Attorney's fees, if you end up going to court, loser has to pay the winner's attorney's fees. This is what I talked about at the beginning. Where the context indicates, the term broker shall also include brokers affiliated licensees. It gives definitions of buyer and seller, meaning, okay, seller, you signed the agreement, but now you created an LLC, and the LLC, you can't get out of basically paying compensation. Fair housing disclosure, because we've got legal and state laws, and it just says, okay, seller, you cannot discriminate based on race, color, religion, national origin, sex, familial status, disability, sexual orientation, or gender identity. This is brand new in 2024. It has to do with this section of the IRS tax code regarding a foreign person as defined in the Foreign Investment Real Property Tax Act, that there are additional taxes that are going to be withheld. If you have any questions about that, get with your closing attorney. This says GAR forms. No one is required to use any GAR form. It goes on to say that regardless of what you're learning in this class, how you portray any documents to your buyers and sellers, what your broker teaches you, what you think you know about this class, what we learned from GAR. The courts, GAR forms are subject to differing interpretations by our courts other than what parties may have intended. You guys, a judge and an arbitrator has full authority regardless of what is signed. And then this goes on, that talks about laws in Georgia. So if you're dealing with people in different states or different time zones or so forth and so on, any prevailing laws are with respect to Georgia laws, and any prevailing timeframes are with respect to Georgia timeframes. Notices must be in writing and signed by the party giving notice. Statute of limitations, 2 years. Survival, what survives this listing agreement is commission, arbitration, and indemnifying the broker. Third-party vendors. This is really great that this is in here, and I'm going to show you a form y'all should use. Broker does not warrant or endorse the performance of any such vendor, and the names of vendors are provided solely as a courtesy and a starting point for the seller to identify possible vendors to perform services on behalf of the seller. Seller agrees to do his or her own due diligence regarding skills, expertise, and reputation of all such vendors, performing services for the seller and the terms of the contracts with the vendors. All decisions regarding which vendor to hire shall be solely that of the seller. In other words, if you hire a roofing expert, a structural engineer, so forth and so on, it is your decision. You are not going based on what I say. And let me show you, GAR has this great document that is very wonderful, and I think you guys should all pull this out. You agents working with buyers and sellers, and I should have already had it pulled up, but I did not. And here it is. Vendor list. And this is a place where you would identify the name, type of vendor. It says phone number. I'd probably put their email address too. And it does say on here, this is what I love. This is provided to you. This is provided by me, the agent / broker, to you, the public, as a ministerial act and as a courtesy. It does not in any way constitute any warranty or representation as the quality of their vendors, their services, or any reports. It is your option to select any vendor of your choice. Broker is not responsible for any guarantees, representations, or warranties of the selected vendors they choose. And you release the broker and the broker's licensee from any liability, from any claim or lawsuit, so forth and so on, in connection with the services. Again, you guys should, all buyers and sellers agents should use this. Form F834, vendor list. And then the next section about brokers and sellers' duties. This is just a reiteration of our Beretta laws. It says what your duties to the seller are. In other words, to try and get the home sold. And the seller has a duty to be timely, make their house available, so forth and so on. Point of practice to you agents. One thing I would do both on the buyer side and the seller side, as soon as you have your public person sign a brokerage agreement, I would pull out a blank purchase and sale agreement, write sample across it, and give it to them to review now before they ever get an offer, or on the buyer side before they ever make an offer. It's much easier. Are they going to read through it? I don't know. But you want to be able to demonstrate and provide them with customer service that you're showing them this information so that if they have any questions, they can make sure to understand what it is they will be signing when they do get an offer or go under contract. And they'll have no pressure because there's no money on the table, no time frame. So again, I think that is, obviously I think it because I'm telling you, I think it's a great point of practice for you guys to all incorporate in your business. It also says, seller, you are responsible for reading all your contracts and understanding them before signing and complying with all deadlines. If you default, this is what constitutes default of the seller brokerage agreement. If you terminate this agreement before the end of the time frame. Now, if you do that, if you terminate unilaterally, you are in default. And I don't agree to it, but I understand that you're firing me or you're terminating our agreement. So I'm going to remove my sign. I'm going to take it out of the MLS service, so forth and so on. That is not evidence of my agreement. That's not the same thing as a mutual termination. It's just saying, I'm not going to continue to market your property when you've terminated the agreement. Big thing to keep in mind, you could be fired from representation, but not necessarily compensation. If a seller fires you or unilaterally terminates this agreement before the end, they still owe you commission based on certain circumstances. And then the other thing that is written here states that a couple of things. A lot of agents have, or a lot of buyers mistakenly think that if a seller gets a full price offer, they have to sell. Well, that's not true. We can't ever require a seller to sell a house. A judge can, but we can't. But what this next section states is your broker is entitled to full commission or compensation if, and that's what's all described here, if they get a written offer to purchase and after taking away all fees, costs, and contributions, the net dollar amount to the seller is at least the full listing price or more. If the amount is to be paid in cash or cash equivalent, if there are absolutely no contingencies, and if the closing is between 30 and 45 days. If the seller gets an offer that meets all of those terms, but they don't take it, you are entitled to commission. If the seller does default, the seller is required to pay the commission that is referenced above. In addition, in the event seller defaults, seller shall, in addition to its other obligations set forth elsewhere, which is the commission, the seller shall also reimburse the broker for out-of-pocket costs and expenses incurred by the broker, including what you can deduct for your mileage according to the current IRS tax rate, any cost of marketing, media, withdrawal fees from MLS services, so forth and so on. So listing agents, point of practice, y'all need to keep track of all the expenses you incur per listing. And then in general, it is so important to warn our public people about the prevalence of cyber fraud, and to, if they get any wire instructions, to cross-verify them from a completely neutral source. Point of practice to agents, you guys do not be the messenger of wire instructions between the closing attorney and your seller. Let them deal with the closing attorney directly. Reference any of the brochures and exhibits. And then again, these are some of the special stipulations that I would suggest. Again, this is going to change to compensation. So for example, if you and your broker agree that if there's no other agent involved, there is going to be a difference in the compensation the seller is going to pay you at closing, you would include that as a special stip. This is what I talked about before. Seller warrants that seller has no knowledge of any latent material defects and will not complete any seller's property disclosure forms. And here's an early termination fee. Should seller terminate exclusive seller brokerage agreement sooner than expiration, seller agrees to pay broker an early termination fee of X amount of dollars. And then they sign this. It is quarter after. Give me a few minutes. Let's go over the authorization to show unlisted property, and then we will take a break so we can come back to the buyers. This is the non-exclusive seller. Again, it's the exact same information other than what I talked about at the beginning. Non-exclusive to any broker. Okay. So again, Georgia, if the seller agrees to sell and changes his mind, can they still be required to sell to a buyer? No, a judge would have to do that. A buyer could, if they go under contract and default on the contract, a buyer would have the option of pursuing the seller for specific performance, and a judge could make the seller go through with the contract, but there's nothing in the contract. Yes, I will show you when we come back from break how to get these forms with all of my highlights. Okay, moving on, we're going to cover this quickly and then take a break. So again, Georgia law says that in order for a public person to be your client, they are required to sign a brokerage agreement. By default, your public person working with you who does not sign a brokerage agreement is your customer. I suggest that you make sure to get a document into the hands of your public people that describes the customer relationship so they understand, and give them the option of being a client rather than a customer. So for a seller customer, this is the GAR form that describes the customer relationship between the seller and the broker. And this is called the authorization to show unlisted property. It is GAR F107. Very similar to what we have just talked about. It doesn't talk about seller, it talks about owner. And you list the name of your broker, a date, and the time frame, the property address, the legal description, the sale price. Don't leave this section blank. Broker hereby identifies known prospective buyers as, put in whatever names of buyers you have or tenants. Fair housing disclosure, commission. Again, this is, GAR did not change this, but they will. This is going to say compensation. This is going to talk about the compensation that the owner agrees to pay you, the broker, at the closing of a transaction. Protection period, just what we've talked about. But here is the important, everything is similar. Here's the important difference. Paragraph 13, no brokerage relationship between owner and broker. This agreement shall not be construed to create a brokerage engagement between the owner and the broker, but is rather limited to the owner's permission given to the broker to show the above property to prospective buyer and or tenant pursuant to the above authorization in exchange for compensation to the broker as set forth above. The parties understand and agree that the owner is the broker's customer and that as such, broker may perform ministerial acts for the owner. It is understood that this agreement is in no way prohibits the owner from selling or leasing the property directly to a buyer or tenant other than the prospective buyers or tenants listed above or subsequently provided by the broker to the owner. Owner shall retain the right to enter into a listing agreement concerning the property with any other real estate broker. And again, as a point of practice, give them this document, ministerial acts. So again, and then they sign it. Just wanted to show you that definitely a good point of practice to, number one, disclose to your seller who is your customer what that relationship means, and number two, get their agreement to compensate you. So let's take a break. I've got 17 after. Let's come back at 11:30, 11:32. We'll do a poll. I'll answer questions, and then we will continue on with the buyer side stuff and the new stuff. So let's take a break, everybody, and I'll see you back in 15 minutes. So, all right, continuing on again. I have spent a long time on the listing documents, and we're going to cover the buyer documents and then the mid-year revisions 2024 that GAR has changed, has revised. You'll see, well, let me just dive in. Instead of telling you what I'm going to tell you, let me just show you. So let me share my screen. And back to the documents. All right. Again, the document that I have underlined is the exclusive buyer brokerage agreement from 1/1/24. However, this is a form that GAR has revised, and the revisions will be available to agents July 1st. So when I get to the revisions, I'll switch to the revised part, but I don't have that whole document underlined, just the revisions. So continuing on, everybody, exclusive buyer brokerage agreement. Just like the seller, there is an exclusive and a non-exclusive. Both of them create the client relationship between your broker and your public buyer. The exclusive means that the buyer has a client relationship with one and only one broker, you. The non-exclusive means the buyer has a client relationship with you, with another broker, and another broker. And the broker that gets paid is the broker that can demonstrate they were procuring cause of sale. The client relationship is created contractually in Georgia, as described in our Georgia law. Everything is very, very similar. There are some differences, and there's some differences to the protection period, but everything else is very similar. So I'm not going to spend as much time as we discussed in depth regarding the seller brokerage agreement. One thing they did change, again, it talks about broker, and in the new revision, it'll say buyer's broker versus just broker. It has a beginning date and an ending date. Describes agency and brokerage and the type of agency relationship not offered. Again, specifically regarding, let me pull up the chat so I can see what you guys are saying. There we go. Specifically regarding dual agency. You all need to disclose it, get written consent. And I don't remember if I said this earlier or not. If you are in a situation where, for example, you have both sides of a deal, or you are working with a public person as a customer, you need to, the reason I keep harping on giving them those documents that describe the client relationship and ministerial acts, you need to give them the option of getting their own representation. Every public person is entitled to being represented by a broker as a client. Now, the compensation for that relationship could come from a different place. For example, let's say there is a contract. Let's say you are the listing agent. You have a seller brokerage agreement signed with a seller. You get a sign call. Buyer is not working with a broker. They want to buy that property. You go through this discussion. They choose at that point in time to be a customer. Buyer and seller go under contract. You are the only broker and the only agent involved. And throughout the course of being under contract and going to closing, the buyer decides, hey, you know what? This is getting a little wonky for me. And I really think I want my own agent slash broker helping me, representing me as a client. They are absolutely entitled, even in the middle of a contract, to hire a broker to represent them as a client. However, the compensation to that broker would absolutely come directly from the buyer because the deal has already been done. So even if the seller and or seller's broker had in the listing agreement agreed to compensate a buyer's broker, if the deal is already done, a buyer's broker cannot, quote unquote, parachute into the deal at that point and be entitled to compensation from the seller side at that point in the deal. But you cannot deny a buyer their own representation. At that point, they're just going to have to pay for that representation, and the buyer's broker needs to have that discussion with the buyer. So I just wanted to make sure to make that distinction that you guys as an agent, when you're working with the public, if they are not your client, you need to make sure that they understand they can always have an agency relationship with someone. So again, representation and compensation are two separate issues. Okay. Commission. All right. Let's move to the revised form for 2020, as of July 2024. So this is the revision coming out to agents July 1st, 2024 from the Georgia Association of Realtors regarding compensation. Little bit different from the listing side. So let's go through it. Paragraph A4, compensation for professional services of the broker, a new title for the paragraph. And then in direct response and compliance with the NAR settlement agreement, which has been preliminarily approved by the courts as of this date, awaiting final approval at the end of the year. It says compensation to brokers is negotiable and is not set by state law. However, this does not obligate individual licensees and brokerage firms to necessarily negotiate their compensation. And then paragraph B says, buyer agrees to pay buyer's broker the compensation set forth at the closing of any contract to purchase. That compensation is expressed as a percent of the sale price, a flat fee dollar amount, or other arrangement. Again, thank you, Georgia Association of Realtors. We are so fortunate to practice real estate in this state. This negotiation of compensation and disclosure and requirement or disclosure of compensation that a buyer pays their broker for professional services has been in our contracts for at least 3, if not 5 or more years. It goes on to say paragraph C, this is new. This is a new paragraph. Optional compensation from seller or seller's broker to the buyer's broker. The buyer hereby approves or disapproves of the buyer's broker receiving compensation from the seller or the seller's broker. Nothing herein should be interpreted as a promise by the seller or seller's broker to pay or offer to pay compensation to buyer's broker herein. If the buyer does approve of such compensation being paid by the seller or seller's broker to the buyer's broker, the maximum amount the buyer's broker may receive from the seller or seller's broker is as follows. That amount is expressed as a % of the sale price, a flat fee dollar amount, or other. This section right here regarding the maximum amount a buyer's broker may receive from the seller and or seller's broker. This is in direct compliance with the NAR settlement. Part of the NAR settlement states that a buyer and a buyer's broker must negotiate and disclose the maximum amount a buyer's broker can receive from the seller side. And you agents, do not leave this blank. The NAR settlement also says it can't be open-ended. In other words, you can't just say any amount offered by the seller. So you can't do that, but you don't leave this blank because this has to account for bonuses. So there are a lot of sellers that will offer a bonus. There's a lot of new construction sellers that offer bonuses in a variety of circumstances, especially at the end of the year, or if it is a new construction seller and you work with them, and this would be like the second, third, fourth, fifth home you've sold for that seller. There is a bonus structure a lot of new construction builders have, and a lot of individual home sellers have incentive to get their home sold by a certain date. For example, there are a lot of sellers that need to get their homes sold so that they can purchase a new home, let's say in a new school district, before the school year begins. So that's just an example. You'll see a lot of individual residential resale sellers say that they will offer a buyer's agent, a buyer's broker, a bonus of X amount of dollars with a contract by such and such date. So you buyer's agents, at closing, your broker can only accept that bonus if the buyer has agreed to it. So thank you, GAR. In the revision, they are including this negotiation where you can put this in here and the buyer can agree so that at closing, if there is a bonus offered by the selling side, either from the seller's broker or the seller, him or herself, you can accept it. So don't leave that blank. Now, the next section, possible reduction in buyer's compensation obligation to buyer's broker. Any compensation the buyer's broker receives from the seller or the seller's broker shall reduce the compensation the buyer shall pay the buyer's broker dollar for dollar, not reduce the compensation the buyer's broker shall pay to the buyer, or special exceptions. Conceptually, agents who've been practicing for a while, conceptually, this has already been in our brokerage agreements. It's just teased out into these separate paragraphs for further clarity to the buyer. So all of these 4 paragraphs go together. So generally speaking, what most buyers would agree to is that, I don't see why they wouldn't, but anyway, they would reduce the compensation. So let me walk you through how this works. The buyer says, I am hiring you, the professional agent, the broker, to represent me as a client to help me find a house property to buy. for compensation for you for the your professional services at closing of a contract, I agree to pay you a certain amount. That amount is either a flat fee or a % of the sale price. I agree, I approve that, guess what? You can also get paid from the seller side of the deal, either from the seller's agent / broker or the seller themselves. And the maximum amount, I agree that you can get paid. Not only that, the maximum amount you can get paid is a such and such amount or such and such % of the sale price. And in your discussion with the buyer, that really is to account for bonuses. Now, because I agree at closing to pay you this amount of money, I'm hiring you to represent me, I'm paying for your services, your professional services, I agree those services are worth X % of the sale price or this much money. You can also get compensated from the seller side of the deal. Whatever you get compensated from the seller side of the deal offsets what I owe you or does not offset. So I don't know why they wouldn't, but offset. So for example, if the buyer does agree that you can get paid by the seller's side, if this amount and the amount, so we used to call this the co-op commission. This typically, not typically, I got to get that out of my vocabulary when talking about compensation. This amount previously is what a lot of agents have referred to as the co-op commission. Seller agrees to pay their broker a lump sum of money. The seller's broker agrees to share that lump sum of money with the buyer's broker. Buyer says, okay, I agree to pay you a lump sum of money, but if you're getting but if the seller's broker is sharing their money with you, then what I owe you is you're gonna subtract what you're getting from the seller side from what I owe you. If what I owe you matches what the seller owes you, then you are paid in full at closing, and I have no financial obligation to you because the amount I agreed to pay you is being paid by the seller side, and my amount is 0. If buyer says, I agree to pay you X amount at closing, seller says their broker is paying, they are paying their broker a certain amount to get their home sold. Seller agrees that the seller's broker is to share part of that with the buyer's broker. The amount that the seller's broker is sharing with the buyer's broker is less than what the buyer has said your services has been negotiated that your services are worth, then there's a difference. So this total amount minus what the seller has agreed to pay you, if this amount is more than what the seller side has agreed to pay you, there is still a commission or compensation obligation at closing on behalf of the buyer. So as a buyer's agent, what do? Well, we're going to talk about that in a second. You can ask for the buyer can ask the seller to pay that obligation to you directly, or you can take it out of closing costs. I'll get to that in a second, but I just want to work through this compensation paragraph. So this paragraph here, first they have to agree that you can or cannot get paid from the seller side of the deal, either from their agent or from them themselves, and the maximum amount. Again, this maximum amount typically is going to cover any sort of bonuses. And then this section says what they agree to pay you is offset by what you're getting from the seller side, or is not offset, meaning you'll get paid at closing from the buyer and you'll get additional compensation from the seller or certain circumstances. And then same thing, it goes on to talk about compensation for a lease. So that is the new revised compensation section on the buyer brokerage agreement. So now let me go back. Is this the buyer brokerage? Oh. All right. And then everything is the same, is similar to the seller brokerage agreement, that it's exclusive. If they are they warrant, the buyer warrants that if they are working with another broker, in other words, if they had signed a buyer brokerage agreement with another broker and they fired them, it was not terminated mutually or with the consent of the broker, they potentially owe their other broker commission. So they are free to go under agreement with you. This is the term. The extension is the same thing that we talked about with respect to the seller agreement. Let's say our buyer brokerage agreement expires December 31st and we go under contract December 15th. Contract doesn't close till January 15th. The buyer brokerage agreement stays intact through closing. And regarding the extension, if I'm working with a buyer brokerage agreement, we go under contract and we end up terminating under due diligence, I can unilaterally extend it, but I have to use this unilateral extension form that we already discussed with respect to the seller. So we've already discussed that. Same thing about dual agency. All of this information we discussed with respect to the seller listing agreement. Okay, the corresponding paragraph B on compensation. Let's look at the revision coming out in July. And again, you will see 7/1/24. That's how you'll know you're working with the revised form. Agents, if for whatever reason you have downloaded to your computer the 1/1 forms, once these come out in July, you have to use the July revision. That is a GAR licensing violation. All right, so the corresponding paragraph to the compensation, new title, compensation for professional services. And it's basically just what we've been discussing. Buyers shall be obligated to pay buyers brokers compensation reference herein at the closing of a contract. Buyer's compensation obligations shall exist even if the closing occurs after. Buyer shall additionally be after the term of this agreement. Buyer shall additionally be responsible for paying compensation if the buyer defaults under this agreement and buyer goes under contract during the protected period on certain properties as explained, which we'll get to in just a moment. Compensation shall be shown on the settlement statement, and it is a closing attorney's precondition for closing. Compensation in any real estate transaction is negotiable and can be paid by any of the parties in a real estate transaction. There are times when the seller or seller's broker in a real estate transaction may offer to pay the buyer's compensation obligation to the buyer's broker. Then it goes on to talk about that if the buyer buys a for sale by owner, that compensation is discussed. Remember, we talked about that on the authorization to show unlisted property. If the seller does not agree to that, then the buyer is still obligated to pay their broker commission, even on a for sale by owner, separate commission on a lease, and the protection period. So I'm sorry, I think I went through it really quickly. Here is the protection period on the buyer's brokerage agreement. You fill in the certain number of days. Here is let me go back. Here is the protection period is a little different than it is in the buyer brokerage. So here is the protection period. I'm sorry, then the seller brokerage. Here's the protection period on the buyer brokerage agreement. The protected period shall be the period of time set forth in this agreement, commencing upon the expiration of this agreement, or what would have been the expiration if the buyer did not fire you by unilaterally terminating, during which the broker shall be protected for its commission or lease commission. There shall be no protection period if the buyer and broker mutually terminate. And I apologize, I skipped over that on the seller side too. If buyer, client, and broker, or seller, client, and broker mutually terminate the brokerage agreement, no protection period. Protection period goes to 0. In the event the buyer enters into a contract to purchase or lease during the term of this agreement, or what would have been the term of this agreement had it not been unilaterally terminated by the buyer, for a property that was shown to the buyer by the broker, either virtually or in person, or which the buyer otherwise visited, those are called protected properties, then the buyer shall pay broker at closing or prior to the commencement of the lease commission. Okay, this is a little different than the seller side protection period. This is more what you guys have in mind of what a protection period is. If you can demonstrate that you showed a buyer a property, or they saw it while you had a buyer brokerage agreement, meaning, for example, they went and saw a residential resale with the listing agent, but you let the listing agent know, or they let them know that they did have a exclusive buyer brokerage agreement with you, that you just weren't there at the time of showing. Or sometimes our buyers will go into a new construction subdivision and talk to the on-site agent. If your buyer has let them know they are working with you and for whatever reason you're not there, and they end up closing on that property after the expiration of your buyer brokerage agreement, those are protected properties. You are entitled to commission by virtue of this agreement, even if the buyer has signed a buyer brokerage agreement with another buyer. Let me make sure this didn't change. With another broker, because those are protected properties. Let me just make sure this didn't change. Yeah, that did not change. So that is more, like I said, in lines with what you typically think of as a protection period. But you agents, you need to demonstrate what those protected properties are. So, point of practice, keep a list of specific properties that you show to a buyer during the term of your buyer brokerage agreement, and give that to your buyer at the expiration or termination of a buyer brokerage agreement, and remind them, if they go back and buy one of these properties, you're entitled to commission, so they may as well bring you back in the deal to represent them. Then it goes on about broker's duties to the buyer, again, as defined by Beretta laws and disclosures, so forth and so on. And the buyer's duties: become familiar with the properties, work exclusively with you, give you a list of any properties that they have seen had they with any other real estate broker, because they may be obligated to another broker for commission. And same point of practice, I highly suggest at the time you have your meeting with a buyer that you give them a sample purchase and sale agreement to review. Buyer acknowledges that if you're working with this buyer and they find you show them a property, you are also working with other buyers, and you may show the same property to more than one buyer. You have no duty to inspect or advise them on hazards, so forth and so on. No duties to the buyer above and beyond what is set forth in this agreement. Same verbiage as in the seller brokerage agreement, and you don't have any authority to bind. The paragraph on broker's liability is the same as we discussed in the seller brokerage agreement. You do have a duty to keep all information confidential unless you are required by law to not keep that information confidential, i.e. anything related to mortgage issues or so forth and so on. And you have no other known agency relationships that would conflict, again, regarding, for example, dual agency. Again, this new paragraph about disclosure of potentially fraudulent activities required by the Georgia Residential Mortgage Fraud Act. We discussed that. arbitration should there be any issues. Loser has to pay the winner's attorney's fees. Broker also means affiliated licensee. This is new in the buyer brokerage agreement that is not in the seller brokerage agreement. Buyer buying property sight unseen. Broker hereby advises buyer there are risks in buying a property without actually seeing it, since pictures, videos, and other information may not accurately reflect the true nature and condition of the property or area. If a buyer purchases a property sight unseen, buyer agrees to indemnify and hold broker harmless from any and all claims, suits, and damages relating to that issue. Again, a buyer and a seller is their extended family, any corporation they're involved in, so forth and so on. Fair housing, GAR forms, all of this is the same as we have discussed in the seller brokerage agreement. Same thing with the vendor information. If the buyer defaults, they owe your broker commission. If they unilaterally terminate this agreement, in other words, if they fire you before the end of it and you don't agree, the protection period gets extended by the amount of time that was left on this agreement. Cyber fraud warning. This is new regarding identity theft. This is new in 2024. You guys, this has been a huge issue. It's so crazy. There are a lot of fake sellers out there that are impersonating a real seller. It's typically with vacant land, and a buyer ends up buying it, and it turns out the seller that signs those contracts never owned the land. So this is disclosure that there is a lot of that fraudulent activity going on, and you're not an investigator, you're not a detective. You do the best you can, so does the closing attorney, but you absolutely highly encourage your buyers to get an enhanced title insurance policy to protect them for that and to not sue any broker. And then again, a reference to the brochures and a signing. So that's the buyer brokerage agreement. Buyer as a customer. This form has been totally redone. So let's talk about this on the new form, and then we're going to cover the other new forms. Revised 7/1/24. Agreement to work with buyer as a customer. This form has been totally revamped. So again, you identify the buyer and the broker and the date. This date is important. Do not leave it blank. All right, hang on one second. And let me just mute everybody. All right. Agreement to work with buyer as a customer. Buyer hereby agrees to work with the broker in locating real property to purchase suitable to the buyer's needs. In working with the buyer, broker shall not be representing buyer as a client, but only working with the buyer as a customer. As a customer, broker cannot represent or advise buyer on brokerage matters, as broker would be able to do if they were representing them, but can only perform ministerial acts on behalf of a buyer. Again, as defined in Georgia law, buyer or broker can terminate this agreement at any time upon written or electronic notice. Customer acknowledgement regarding commission. That's probably an oversight. That'll be changed to compensation. Broker will have the right to share in the compensation being paid to the seller's broker on any property purchased by buyer if broker is a procuring cause of sale. Arbitration if there are any disagreements, so forth and so on. All right. Compensation. In the previous customer acknowledgement, this was missing. If any of y'all took my classes prior to this, I made a bet. I was 99.9% confident that the revision for the buyer customer acknowledgement would include compensation, and it does. Compensation for professional services. At this point in the class, this should not look new to you. Generally, compensation to brokers is negotiable and is not set by state law. However, this does not obligate individual licensees and brokerage firms to necessarily negotiate their compensation. Compensation to buyer's broker. Buyer agrees to pay buyer's broker the compensation set forth below at the closing, as expressed in a percent, flat fee, or other. Optional compensation from the seller or seller's broker to the buyer's broker. Buyer hereby approves or disapproves of the buyer's broker receiving compensation from the seller. Nothing herein should be interpreted as a promise by the seller or seller's broker to pay or offer to pay compensation to the buyer's broker. If, however, the buyer does approve of such compensation being paid by the seller or the seller's broker, the maximum amount is again expressed as a percent, flat fee, or other, and any compensation the buyer's broker receives from the seller or seller's broker shall reduce the compensation the buyer shall pay, not reduce or special circumstances. It's exact same verbiage in the buyer brokerage agreement. Okay, don't leave this blank. It's hard to see this. You guys don't miss this when you're filling out your contracts. Buyer shall be obligated to pay buyer's broker the compensation referenced above at the closing of any property that the buyer purchases that was shown to or identified by buyer's broker to the buyer within the later of so many days after the date of this agreement. Here, remember I told you the date's important. So reference so many days after this date, or the last date the buyer's broker showed any property to the buyer. Notwithstanding the above section, it shall not apply if the buyer enters into exclusive buyer brokerage agreement with another broker. And then all of this is the same. Buyer's duties are the same. This is brand new. And I'm sorry, I apologize. This is a new paragraph in the revised versions of the seller brokerage agreement and the buyer brokerage agreement and the customer agreement. And this is based on Georgia law. Certain disclaimer regarding purchase of certain properties. There is a Georgia law, and the buyer acknowledges that this law prohibits certain non-resident aliens, foreign persons, foreign companies, and U.S. companies owned by any of the above from buying or possessing certain land within a 10-mile radius of any military base, military installation, or military airport. If the buyer fits into one of these above categories, the buyer agrees to read the above code section before contracting to buy land. Buyer should consult with legal counsel to fully understand. Buyer agrees to indemnify and hold broker harmless from any and all claims, causes of action, suits, and damages arising out of or relating to their failure to comply with the law. Violation of the law can result in civil or criminal penalties, and the law may require them to divest themselves of such property. 2-year statute of limitations, cyber fraud, covenant not to sue, and all of this is the same as disclosures. So that is the new buyer brokerage agreement. Non-exclusive buyer brokerage agreement is the exact same thing, other than it's non-exclusive. That's it for the brokerage agreements. Now, for the last part, let me cover more forms that GAR has revised in July, especially regarding compensation. And it fits in with this class because the working with the buyer and the seller, that's how we get compensated, is from them. So we are going to continue on, and I do want to cover those issues. So here we go, ready to dive in, and I will answer, there was that question before the break. Additionally, you guys are asking where you can get copies of these underlines. I'm going to type it in the chat. If you go to, wait, I can't type and talk at the same time. If you go to, scroll down page for class. All right. There is a website. We're trying to get it on the Georgia the Real Estate Academy of America website, but we haven't done that quite yet. If you go to eAgent, if you go to, okay, let me share my screen. I'll show you that. Well, let me go over the new forms and then I'll cover that. If somebody says they're not there, Cindy, if they're not there now, I'll make sure they're there this afternoon. So they will be there. Okay. Let me go back to sharing my screen and let's cover these new forms and then I'll go back over that. So let me see the chat over here. All right. Oh, for this class, you got to, okay, I'll put them up for this class. I don't think this class is up yet, so I will. All right. New forms. So there is, this is not a new form. This is a form that has been revised. This form used to say commission agreement, co-op commission agreement to be used prior to showing. In July, it now says pre-showing compensation agreement. So with the NAR settlement, part of that agreement is that the co-op fee is no longer going to be referenced in an MLS service that is an NAR member MLS service. Specifically, Georgia MLS is an NAR member MLS service. Navica is an NAR MLS service. FMLS is independent. Just so y'all know, FMLS is independent and it is not a member of NAR. Therefore, they do not have to comply with any of the NAR settlement issues because they have nothing to do with NAR. So as of right now, FMLS is still showing, and according to the preliminary settlement, this goes into effect August 17th, whatever that Monday is. I think it's the 17th. August. Am I in the wrong year? Anyway, okay. I'm sorry. August 17th, 14th. I don't know. Anyway, okay. FMLS not only is still showing co-op compensation, FMLS also has a brand new remarks section. They've got public remarks, private remarks, and compensation comments. So FMLS is still showing this. FMLS is independent and does not have to follow any of the NAR settlement issues because they're not a member of NAR. Georgia MLS, however, and the majority of other MLSs, I don't know of any other independent MLS, at least in our area, in Metro Atlanta, that is independent. They are taking all of that out. So there is nothing in the NAR settlement against co-op commissions or co-op compensation. Sellers can still allow their brokers to share the compensation with a buyer's broker. However, as a buyer's broker, you're going to have to communicate with the seller's broker to find out what, if any, compensation is coming from their side. You're not going to readily see it communicated through at least Georgia MLS. You might through FMLS. There's nothing against a co-op compensation. And it can be communicated anywhere else other than an NAR member MLS service and showing time, because showing time is related to MLS. My understanding as of this date, 6/12/24, it may change, but as of today, my understanding is listing agents can attach, you know, like on the MLSs where you can attach a document like the lead-based paint disclosure, seller's property disclosure. My understanding is you can attach a document related to compensation. That would either be instructions to closing attorney, this pre-showing compensation agreement, or any other document. That may change, but that is my understanding right now. This new form is not new. It's a revised form. It used to be co-op commission agreement to be used prior to showing. The date is important. So you identify the property, and it states that the seller and or the seller's broker, depending on who is paying the compensation to the buyer's broker, hereby confirms to buyer's broker the compensation for professional brokerage services to which the buyer's broker shall be entitled In the event the buyer with whom the buyer's broker is working with or representing, and who will be identified in any offer made by such buyer through the buyer's broker, contracts to purchase and closes on the property. Such compensation shall be paid to buyer's broker by the party identified below at the closing of such transaction. The agreement is contingent upon the offer to purchase that's made through the buyer's broker working with or representing. Working with means the buyer's broker is working with them as a customer. Representing means the buyer's broker is working with the buyer as a client. So it doesn't matter what the relationship is, that public buyer is still working with the broker. The buyer being delivered to the seller's broker, so the offer has to be delivered to the seller's broker within so many days of that date. The offer of compensation shall expire if no offer to purchase the property is made within the time frame and this pre-showing compensation agreement is not otherwise extended by agreement of the buyer's broker and the party paying the compensation. So it is described compensation. Again, this is from the seller side. Compensation being offered to the buyer's broker. This is how much, and this is who is paying it. The amount expressed as a percent of the sale price, a flat fee or other, and it is being paid by the seller directly in addition to what the seller is paying their own broker. It is being paid by the seller's broker. They're sharing it out of the compensation, the total compensation the seller is paying them, or a combination between the seller directly and the seller's broker. And then it goes on to say there's no claim for compensation if there's no closing, and buyer's broker and all other parties and broker signing have the right to rely on this. It goes on to say that this pre-showing agreement shall not modify or amend any separate agreement regarding the buyer's broker compensation. So again, the buyer in the buyer's brokerage agreement or the buyer customer acknowledgement, the buyer agrees to pay their broker a certain amount of compensation at closing. This agreement does not change that, but this agreement could potentially offset, this is money coming from the seller side, could offset the buyer's obligation depending on how you filled out those paragraphs we just talked about. Here's this paragraph G that says, if the compensation being offered to the buyer's broker is more than the buyer's broker is permitted to accept, and the buyer does not consent to the additional compensation, then the offer of compensation herein shall be reduced to the amount of compensation the buyer's broker is permitted to accept. Remember, that's where I told you guys, do not leave this section blank where it has let me go back up here. Maximum amount. Don't leave that blank because this is what this is referring to. If that is left blank or is not filled in, then any of this is left on the table, not permitted to accept. Any licensee signing this agreement on behalf of their broker warrants they have full authority to sign and bind the broker to the compensation agreement, and then it is signed. If the seller, so this is just signed, so this is what we are used to thinking of as a co-op agreement, so it's signed just by the brokers. However, if part of the compensation is coming directly from the seller, then the seller also has to sign this. It says if the seller is paying buyer's broker compensation referenced herein, the seller has to sign it. Seller does not need to sign this agreement if all compensation to be paid herein is being paid by the seller's broker. This verbiage is also in the instructions to closing attorney. All right. Then this is a brand new form. This is broker compensation agreement exhibit. This agreement should not be used if the broker's compensation and the party or broker paying it have already been agreed to in a separate written agreement and is not being modified. In other words, the parties, the brokers have already signed this pre-showing compensation agreement or instructions to closing attorney. If that's already signed, you do not need this exhibit. This is not a blanket exhibit that agents should be using with every offer. Let me go over it, and then I'll give you best practices. When would be an appropriate time to use this exhibit? This agreement should not be used. I just said that. Broker compensation. Again, this is an exhibit. So you put in the day. This is going to be an exhibit to an offer made by a buyer. You identify the property, you identify the buyer and the seller. This says, I think this is going to change to brokers rather than buyer's broker. Compensation being offered to brokers. The compensation of the undersigned brokers for professional brokerage services provided in the above referenced transaction is set forth below and shall be paid by the following party or broker. Compensation of the buyer's broker. How much and who's paying it? Compensation of the seller's broker. How much and who is paying it? So expressed as a percent, flat fee other. Compensation of the buyer's broker shall be paid by, and this can be more than one party. This can say compensation of the buyer's broker. This is the total amount that is going to appear on the closing settlement statement that the buyer's broker is getting at closing. How is this being paid? Well, a certain amount is being paid directly from the seller's broker. A certain amount is being paid directly from the seller, and a certain amount is being paid directly from the buyer or any combination thereof. Same thing with the seller's side. This is the total amount that's going to show on the closing settlement statement being paid to the seller's broker and how that is divvied up or who is paying it. This is enforceable and binding upon the parties and brokers signing it. This is confusing. It says, even if it is not signed by all parties and brokers, the purchase and sale agreement for which it is attached. It is not binding upon any broker who does not sign and consent. Any licensee has permission on behalf of their broker to sign it. If it can't be further modified without the express written permission. So again, you guys, this is an exhibit to your purchase and sale agreement. Typically, when you are an agent preparing an offer, your broker doesn't sign your offer, you sign it. That's why this paragraph says it's still enforceable even if the broker hasn't signed it, because you as the agent have signed it, and you have the authority to sign. It is signed by the buyer and by the seller, and it is signed by both brokers. This is one exhibit that if it is not signed by all of these parties, it is not enforceable. Other exhibits are enforceable, even if not signed, but not this new one regarding compensation, and that is what is disclosed here. So when would you use this? Well, best practice would be for you buyer's agents. Best practice would be for you seller's agents. If your seller is agreeing to pay compensation to the buyer's broker directly, or if the seller has directed you as their agent to share part of the compensation they are paying you with a buyer's broker, best practice is for this listing agent to disclose that up front and make it easy for a buyer's broker to see that information. Why? Well, a couple of things. Number one is the buyer has an obligation to pay you commission. If you filled out that form that their obligation to pay you commission is offset by the seller side, then before they go to see a house, you can say, look, I have in writing pre-showing compensation agreement. Here, buyer, the seller side is paying my broker's commission so much. Do you want to, and if this amount equals the amount the buyer has agreed to pay you, obviously the buyer's going to want to go see that house. If this amount is less than the amount the buyer has agreed to pay you, the buyer at closing is going to have a commission obligation to you. So you would show this to the buyer and say, okay, buyer, if we see this house and you buy it at closing, you're going to have a compensation obligation. Do you, buyer, want to see this house or not? And let the buyer tell you yes or no. If, however, you buyer's agents, you have no information of any co-op fee coming from either the seller's broker or the seller, and there's a house the buyer wants to see, you have that discussion with the buyer that at closing, they're going to owe you, they have a commission or compensation obligation. They want to see it anyway. You go show the house. You still have no communication with the seller listing agent. You have no idea if there's any compensation coming from their side. You write an offer on behalf of the buyer. In that situation, you have gone into that offer blind to any compensation coming from that side. That would be a best practice to use this exhibit to say, okay, the buyer, we're going to first start off with this exhibit saying that compensation for the buyer's broker shall be whatever amount compensated by seller's broker. And put this, whatever that is. Let the seller and the seller's broker either sign it or make you a counter offer. If this is an exhibit to the contract, if the seller agrees to every other terms but doesn't agree to this, you are not binding. You have a counter offer, and you would then negotiate through this. If, however, like I said, you already have this signed, you would not use this exhibit. There are a couple of other ways. Bear with me 2 more minutes. There are a couple of other ways a buyer may ask the seller to compensate their commission obligation. The first way is with a special stipulation that GAR has had from the beginning of the year, and they have revised it. They have revised it in 2024. So you would go into, if the seller's side compensation to the buyer's broker is less than what the buyer has agreed to pay their broker at closing, then the buyer can ask, include this in as a special stipulation in an offer. This VA one is going to close, if y'all don't know, as of yesterday, 6/11/24. The VA has allowed a VA borrower to pay their agent's commission. So let's just look at this special stipulation. You would use this special stipulation. Buyer hereby requests seller hereby agrees to pay the buyer's broker at closing the following compensation for professional services: blank dollar amount, blank percentage of the sale price, or other. Nothing herein shall be interpreted as a request to alter, modify, or change the commission. That should probably be changed to compensation to be received by the seller's broker, if any, that the seller has agreed to pay their broker. So what the seller agreed to pay their broker is not being changed by this special stipulation for the buyer asking the seller to pay their broker's compensation. So that's one way. So we've got 3 ways now. Number 1 is using that exhibit, and that would be one way. The second way would be to use this special stipulation. And the third way is, let me show you this. In the GAR purchase and sale agreement, in the GAR purchase and sale agreement, it has it also in the section under closing costs. So if the buyer and seller negotiate for the seller to make a contribution of X amount of dollars towards the buyer's closing costs, then what it says here is, at closing, seller shall make the above referenced seller's monetary contribution which the buyer may be used to pay any cost or expense the buyer related to the transaction, including without limitation any commission obligations of the buyer. You do have to get lender approval. So back to our forms. If the buyer has agreed to pay this total amount, the buyer agrees to compensate their broker at closing. If the buyer's broker is getting that full amount from the seller side, there is no buyer obligation for commission. There is only a buyer obligation for commission if the amount the buyer's broker is getting compensated from the seller side is less than this amount. Then there is an obligation, and then the closing attorney can use, with the lender's permission, part of the closing cost to offset that contribution. So that is the situation where that would be 3 situations where the buyer can negotiate for the seller side to compensate their broker. The special stipulation, coming from closing costs, or using this exhibit. And then one more thing to show you guys, in the consumer brochures, in the revision in July, GAR has added this new section. It's under protect yourself when buying real property and protect yourself when selling real property. And it just goes through everything we've been discussing. Broker's compensation for professional services to the broker. A broker's compensation in Georgia and who pays it is always negotiable. Such compensation can be paid by the seller or buyer or both. Some buyers will ask the seller to pay the compensation the buyer owes to the buyer's broker. They may do this for a couple of reasons. First, if the buyer's getting a VA loan, the buyer may not be permitted under the loan program to pay the buyer broker's compensation. Others, particularly first-time home buyers, may not be able to afford to pay the buyer's broker's compensation if it is not included in the buyer's mortgage loan. When a buyer asks the seller to pay the compensation owed by the buyer to the buyer's broker, the buyer is effectively making the compensation part of the sales price for the property, because most sellers will focus on their net proceeds after the broker's compensation is paid. When the seller is not initially offering to pay the buyer's broker's compensation and the buyer wants the seller to pay this obligation, the buyer will usually include a special stipulation to that effect in their offer to purchase the property. If permitted by the buyer's lender, the buyer can also request the seller to make a monetary contribution at closing as per the GAR purchase and sale agreement, which can then be used by the buyer to pay for, among other things, any compensation owed to the buyer's broker. I highly suggest you guys use these consumer brochures, the buyer one for your buyer, CB13, and CB10 with your sellers. It has that same section in there. Woo! All right, everybody. We made it. Those handouts will be there by the end of the day. I do have the new the highlight, my underline forms. I also, again, have my real estate channel, Real Estate Made Crystal Clear. I cover all of these things in depth. And I will have the highlights for this class as well as this recording up there. The forms will be there by the end of the day. The recording will be up there in a couple of days. I appreciate your time. I hope y'all learned a lot. I give glory to God for being able to be a blessing, hopefully, to y'all with this class. And I encourage all of y'all to go be a blessing with your real estate license to your buying and selling public. I will, before you leave, please type in your name, email address, and license number. Thank you guys so much. Bear with us as we learn more information. We will have updated classes. Check your sales meetings, check with your brokers, check my YouTube channel as things progress. And some of these GAR forms might get tweaked a little bit. And you'll definitely want to take a new contracts class next year, which we typically teach the new contracts in December. But stay tuned and feel free to reach out to me. I'll be happy to help with any way I can. Because everybody's typing in all their information in the chat, feel free to